This is the story of how a legal loophole nearly killed an entire sport twice, 30 years apart, and how the second time around, it almost took a shoe company down with it. In 1976, skateboarding did not have parks. It had driveways, drainage ditches, and empty swimming pools that belonged to somebody else. Then a company in Florida figured out how to pour concrete into the shape of those pools on purpose, and everything changed. Port Orange, Florida got one of the first major commercial skate parks that year. Carlsbad, California got one soon after. Within 2 years, the idea had spread across the entire country like wildfire. By October of 1978, there were 200 skate parks open for business in the United States. 4 months later, in February of 1979, that number had doubled to 400. Investors saw a gold rush, kids saw freedom, insurance companies saw 100 lawsuits waiting to happen, and they were right. Vert skating is what did it. Riding a flat driveway is one thing. Riding a 16-foot deep bowl, learning to pump transitions, throwing your body at coping you have never touched before, that is something else entirely. Skaters were flying off decks and landing on concrete over and over, park after park, and every single one of those falls came with a name attached and a lawyer not far behind. By 1979, injury litigation against skate parks had exploded. Insurance underwriters looked at the claims piling up and did the only thing insurance underwriters know how to do. They panicked, and they raised the price of coverage until it was no longer survivable for a business built on $5 admission fees. Here's the part that gets lost in most retellings. It was not one lawsuit, it was not one skater, one court case, one headline you could point to. It was death by 1,000 liability claims, each one small enough to settle quietly, but together large enough to wipe out an entire industry. By the start of the 1980s, the number of insurers still willing to write a policy for a skate park had dropped to 1. Then it dropped close to 0. Parks that had cost hundreds of thousands of dollars to build could not get covered for any price, and once you cannot get insurance, you cannot legally stay open no matter how many paying customers are lined up at the gate. The result was brutal. Of the 400 skate parks that existed at the start of 1979, fewer than a dozen were still standing by 1980. Not damaged, not struggling, gone. Bulldozed, drained, filled with dirt, forgotten under parking lots and strip malls. An entire built environment poured in concrete over 2 frantic years, erased in about 18 months because nobody had figured out who was legally responsible when a kid broke an arm doing a trick he chose to do on his own 2 feet. So skateboarding did what it always does when the world tries to shut it down. It went underground. Through the 1980s, the sport survived in backyard ramps, drained pools skated at night, and parking garages run by kids who had learned the hard way that you cannot sue your way into a healthy sport. Whole careers were built on plywood ramps in someone's backyard because there was nowhere else legal left to go. It would take almost 20 years and a completely different legal strategy for skate parks to come back out into the open air. The riders who lived through that first collapse do not describe it as a policy failure. They describe it as watching their whole world get bulldozed. Skaters who had learned to pump a bowl at a park in their hometown would show up one weekend to find the gate padlocked and a demolition crew already moving in, the concrete they had learned to trust under their wheels broken up and hauled away within days. There was no warning system, no transition period. 1 month the park was open for business, charging a few dollars at the door. The next month, the insurance policy had lapsed and the owner had no legal choice but to close because operating an uninsured skate park meant staking a family's entire savings on nobody ever getting seriously hurt again. Some owners tried draining the concrete bowls and renting them out as makeshift storage. Most simply walked away. That strategy had a name: hazardous recreational activity law. In 1997, California passed Assembly Bill 1296, and it changed the entire calculation overnight. The law said that if you are 12 years old or older and you are doing stunt or trick riding at a public skate park that meets specific safety requirements, then skateboarding is legally classified as a hazardous recreational activity. Under California Government Code Section 831.7, that classification gave public entities immunity from most ordinary injury lawsuits tied to the inherent risk of the sport itself. Cities could finally build skate parks again without signing up for bankruptcy. Over the next decade, public parks opened by the hundreds, from small suburban bowls to massive concrete plazas. The sport that had been legislated into near extinction had found the exact piece of legal language that let it come back to life. But there was a catch nobody had tested yet, and it was sitting inside every private skate park in the country, printed on a clipboard at the front counter. Public parks had their new immunity. Private parks did not. They ran on something older, and everyone assumed simpler, the liability waiver. Sign here before you skate. If you are a kid, your parent signs for you. For years, everybody in the industry assumed that piece of paper was bulletproof. Nobody had actually taken it all the way to a state Supreme Court. Then in January of 2003, a 12-year-old named Andrew Hojnowski broke his leg at a skate park in New Jersey, one that was owned and operated by Vans. Vans, the shoe company. The same skate shoe brand you have probably owned a pair of. Vans had built a chain of indoor skate parks inside shopping malls, partly to sell shoes, partly to build brand loyalty with an entire generation of skaters, and on Andrew's previous visit to that same park, his mother had signed the standard waiver required for him to get in the door. Andrew's family sued anyway, and Vans pointed straight at that signature. That is what the waiver is for. The case climbed the New Jersey court system for 3 years. And on July 17, 2006, the New Jersey Supreme Court delivered a ruling that shook every skate park operator in the country, along with every trampoline park, climbing gym, and youth sports league watching from the sidelines. The court said a parent can agree to send a dispute to arbitration on a child's behalf. That part was fine. But a parent cannot sign away a child's right to sue for an injury before it happens. Not for a skate park. Not for anything. The court's reasoning was almost brutally simple. A parent might not be able to afford a child's future medical care if something goes catastrophically wrong, and the state was not going to let a piece of paper erase that safety net in advance. Judges called it the parent's patriot duty, the government's obligation to protect children even from their own parents' decisions. Overnight, the single legal document that every private skate park in America depended on for minors had a hole in it the size of a swimming pool. Think about what that meant commercially. By 2006, skateboarding was not the underground scene it had been in 1985. It had X Games television deals, professional leagues, shoe contracts worth real money, and indoor park chains built specifically around getting kids through the door. Vans alone had sunk serious capital into an entire network of skate parks as a marketing arm for its footwear business, banking on those parks to turn casual riders into lifelong customers. And now the core legal protection behind every one of those locations for every rider under 18 was gone in a single afternoon in Trenton, New Jersey. This is where the story could have repeated itself exactly. Another wave of impossible insurance premiums, another wave of closures. Skateboarding pushed underground for a second time in 30 years. It did not happen that way, and the reason is worth paying attention to, because it is the same reason skateboarding has survived every legal threat thrown at it since the 70s. The industry adapted instead of collapsing. Operators leaned harder into the one part of the ruling that had actually survived: binding arbitration clauses, which the court explicitly said parents could still sign on a child's behalf. Parks across the country rewrote their intake paperwork almost immediately, routing disputes into arbitration rather than trying to waive liability outright, since arbitration was still legally standing even after the waiver itself had been gutted. States began expanding their own hazardous recreational activity statutes, borrowing directly from California's playbook. Insurance markets, older and more sophisticated than they had been in 1979, finally built real actuarial models for skate park risk instead of just panicking and pulling every underwriter out of the market at once. None of this stayed a niche legal footnote. Skateboarding made its Olympic debut in Tokyo in 2021, and the sport's global market, spanning hardware, apparel, footwear, and licensed park construction, has been valued well into the billions of dollars since. Every new municipal skate park built after that debut, and there have been thousands of them, was constructed on the legal foundation those two fights laid down decades apart: California's hazardous recreational activity statute protecting the public parks, and arbitration clauses protecting the private ones. City planners drafting a skate park proposal today are, whether they know it or not, working inside the exact legal framework that survived a state Supreme Court ruling in 2006. The plywood and concrete get all the attention, but the paperwork is what kept the lights on. 30 years apart, skateboarding faced the exact same fundamental threat twice. Who pays when a kid gets hurt doing something inherently dangerous by choice for fun? The first time in the 70s and 80s, nobody in the industry had an answer, and 400 skate parks turned into a dozen almost overnight. The second time in the 2000s, the sport had learned enough about its own legal exposure to bend instead of break, and skate parks kept their doors open while the paperwork underneath them got rewritten in real time. That is the part people miss when they talk about skateboarding's history. It usually gets told through tricks, through athletes, through video parts, and magazine covers. But the sport's survival was decided just as much in insurance actuary tables and state Supreme Court opinions as it ever was on a piece of plywood. The billion-dollar question underneath all of it was never really about skateboarding at all. It was about who is responsible when someone chooses to take a risk. Skateboarding just happened to be the sport that forced America to answer that question twice in 2 different centuries, and both times it was the sport itself, not the lawsuits, that found a way to land on its feet.